Hello, everyone, and thank you for joining us today for our webinar, Ask Us Anything. Venable attorneys answer your questions about all things advertising and marketing. I'm Shaheen Rothermel. I'm an associate in Venable's Advertising and Marketing Group, and I'm joined today by Ari Rothman, who is a partner in Venable's Advertising and Marketing Group, as well as in our litigation group. We really appreciate all the questions that we received from everybody and the engagement and a lot of really interesting questions came in. And as a result, we'll be able to answer some of those questions. If we don't get to your question during the presentation, we'll reach out separately to make sure that it was addressed. And if you have any questions, you can ask them in the Q&A portion, and we'll try to get those to you as well. What we'll be talking about today, we had a couple of recurring questions on a few topics, which were email marketing, social media marketing and customer reviews, and competitor challenges. And so we're going to go and do a little bit of an overarching review of those topics. And we received a couple of one-off questions as well about other topics. And so we will address those at the end of the presentation as well. So with that, I'd like to hand the presentation over to Ari for him to talk about email marketing.
Thank you, Shaheen, and thanks everybody for joining. And thank you for asking questions about email marketing, one of our favorite topics here. So we'll cover the very high-level summary of email marketing, and then we'll answer some of the specific questions that came in. So email marketing, there's two bodies of law that govern email marketing in the United States, federal law and state law. Pretty simple. The federal law is the CAN-SPAM Act, and that is the federal law that regulates commercial email messages. CAN-SPAM's main provisions are it's no false or misleading header information. That would include a subject line. You must indicate the commercial nature of the message. In the past, we've seen questions about, does that mean you have to say, this is an advertisement in the subject line, or do you have to be that express about it? The answer is that's always safe to do somewhere in the body of the email. You can't really go wrong with that. But if it's as obvious as today is Wednesday that the email is a commercial advertisement for something, then you should be fine. And we haven't really seen that many, or I don't know that I've seen any enforcement actions from the Federal Trade Commission, the Justice Department, if they somehow decide to prosecute, or even class action lawyers or private plaintiffs prosecute that point. But it is a requirement, and so it's something to keep in mind. We see more of the deceptive subject lines and false or misleading information in the header or obscuring the sender. Those are the kinds of claims that we typically see. Can't do that. It has to be transparent so that the ISP or the recipient can identify where the email came from. Opt-out, everybody, I think, understands that by now. The emails have to have opt-out, and it has to have the sender's valid physical postal address. That's to address any concerns from people who think that by clicking an unsubscribe link or sending an email to the sender that they're just going to get more emails. And advertisers may be liable for actions of affiliates and third-party vendors. So if you're a marketer, you're an advertiser, you just can't pass the emails off and escape liability. So that's the top level on CAN-SPAM. Then there is the second category of laws, which are state laws. For this purpose, since we've got a lot to cover, we're just going to cover California anti-spam law. That is the one that by far and away is the most litigated in the country. It applies to emails that are sent to California email recipients and email sent from California. So if you are sending an email from, name your state outside of California, just go Missouri, it's nice right in the center of the country, into California, you as the Missouri company will be liable for that email. Unlike CAN-SPAM, which can only be enforced by the government and internet service providers, the California email statute can be sued. People can sue under it if they are a recipient, so individuals, the Attorney General, and internet service providers as well. And so we see a lot of action here in the California Anti-Spam Act, up to $1,000 per email, and then up to $1 million before a due care reduction. This is probably, again, the most, creates the most exposure for private parties in terms of private litigants and private plaintiffs pursuing claims under the statute. This has created the most litigation activity over the years. We're seeing a lot more of it in the last year or two. It was sort of really hot, late 2000s, early 2010, 2011, 2012, and it slumped off, and then it came back around 2015, 16, then slumped off again. And now we're on an upward trajectory, and we were on that upward trajectory before COVID, and it hasn't stopped. There's new plaintiffs, lawyers arriving on the scene, and they're being pretty prolific about filing these things. One of the questions that came in, we've got the general requirements here. We had a few questions on California email marketing. And one of the questions was, is this the new TCPA? And the answer to that is yes and no. The first thing I would say in response to that question is that the two laws are very different. I mean, the TCPA covers in the large, and again, this is shorthand and we could do a whole presentation on it, but unsolicited text messages and phone calls using an automatic telephone dialing system to a cell phone. That's the most common claim we see. There's also claims, to pre-recorded voice messages to homes and that kind of thing, but it's just a mere unsolicited message can trigger liability, and then depending on what that message is or says will depend on what kind of consent you have to have. Under the California Anti-Spam statute, the contents of the overall message are really focusing on the header and the subject line. That has to be materially false and misleading in order to trigger liability. And the reason for that is because CAN-SPAM preempts the statute in all state statutes except for material falsity or deception, which is another way of saying merely sending an unsolicited commercial email that's completely truthful in every way and that isn't sent to somebody who unsubscribed to receiving emails from the sender is perfectly legal. That's a big difference compared to the TCPA. So you can send as many truthful, unsolicited emails as you want, as long as you're not sending them to email recipients who have requested not to receive them, and you're not sending so many. And it's really hard to do this, but technically it's in the case law. You're sending so many emails that you jam somebody's server or shut off their computer or something like that. That's really hard to do, but that would be the other prohibition around it. In terms of how many lawsuits like this we're not seeing as many in the TCPA, because the TCPA, it's really easy to certify a class. Who received, theoretically, if you've got a phone number list or who received the messages, where they are, if they're in the U.S. or not in the U.S., roughly when they receive the message, and you probably know or may know, depending on what the text message logs say, what the message said. Email's a lot trickier because under the California statute, again, it only applies if the email was sent from California or into California and received by a California recipient. And unlike cell phones, for example, you don't know based on an email address what state that person lives in. So if a consumer's email address ends in gmail.com, you've got no idea looking at that email address whether they're in California, whether they're in Nevada, whether they're in Texas, whether they're somewhere else. And so it's a lot more difficult for plaintiffs to certify those classes. And so the strategy then ends up being, let's just gather up as many of these emails as we can, as many plaintiffs as we can who receive similar emails, 5, 10, 15, 20, whatever it takes. If they each have 10, 20, 30 emails, all of a sudden it's 200 emails times $1,000 each. there's a real case there. We've seen cases as many as 2,000 emails. And so it's a TCPA in that respect, but it eliminates the class certification aspect, although we still see plaintiffs attempt class actions, but no class has been certified as far as I've seen, except in one case, and that was a settlement. So no judge has certified a contested class. So that answers, I hope, the question about is it the new TCPA? We have the other question about aren't state laws governing email marketing preempted, and just went through that pretty quickly. The statute is not preempted, but claims arising under it might be. If it's a completely truthful email, you can tell who's identified in it or who's advertised in it. The advertiser is clearly and accurately identified in it. There's nothing messy about the from name. It doesn't say it's from a bank, and then when you open it up, it's for a dating site. You're probably going to be okay. That will probably be preempted, even if, the bank example wouldn't be, but if you have somebody in a from name that isn't the actual sender, it's more of a generic name, but in the body of the email, it's clear that, for instance, it's a dating website, and the from name wouldn't lead the reader to believe that it's from somebody other than or associated with a dating website, that's probably be preempted. And so that's another way of answering the question. We had a question come in that says, don't state laws only prohibit falsity? They're only allowed to prohibit material falsity. So if the statute also says it's illegal to send unsolicited commercial emails, if a state statute were to say something like that, that part of the statute would certainly be preempted. I think Sheen's driving this a little bit. Do we cover all the questions on email marketing?
Yeah, I had one follow-up that I've gotten offline, and one of the issues that we're seeing is that we see some clients who are constant targets of the California anti-spam law, and we've seen other clients who, for this question, don't know that that's even an issue. They think there's canned spam, and that's all. Can you just briefly talk about, I know you do a lot of these, could you talk a little bit about, how you've seen these cases arise, and why do you think that some clients or some companies tend to be targeted more in these actions than others? And sort of along with that, who tends to be targeted? We know that there's liability sort of across the chain, up and down, if it's the publisher, if it's an affiliate network who's brokering the emails, if it's the advertiser or the brand that's being promoted in the emails.
Yeah, so the current trend, before the case law sort of got developed, the plaintiffs would try and sue whoever they could connect to the emails. It could have been the advertiser, the affiliate network, the publishers, if they could figure out who that was. Less so the internet service providers, they're exempt, so you wouldn't see Comcast getting sued for these. At least I've never seen that under this statute. Now what we're seeing is the plaintiffs are going for the advertisers. They are suing the advertisers. And there's two kinds of attacks that we're seeing. The first attack we're seeing is an attack where the plaintiff's lawyers know how to trace the emails and identify who's advertising them, even if on the face of the email, they do not identify the advertiser. So let's go to just tires. I'm just making that up. I don't think I've ever had a tire spam case. But there's an email that comes in, and the creative is of a tire. Doesn't say who's selling the tires, doesn't say what brand the tire is, but the plaintiff's lawyers look at that and they're like, look, this doesn't identify the sender. And then there's this weird ad about something unrelated to the tire below the tire creative, and then above it, the from name is from a bank, and so this email is just really messed up. They know how to figure out who the end advertiser is. It's not that hard. They click on the email, they arrive on the website, they capture all the redirect links, and from there they find their defendants. And from that perspective, the common elements we see in those kinds of cases are it's generic, the advertiser is not named, there's no information that's readily available from the face of the email about who's sending it, and in my example, the from name is completely false. If it's the name of a bank, the bank didn't send it, they open it up, it's about tires, let's say the subject line says, get your free photo frame or something like that. So now you've got a misleading subject line. Those are things that actually happen. A lot of the times it's not intentional, but we see them and they're targeted. And those tend to be decent cases in California. The other ones we see are the name brand is in the email 7 ways to Sunday. I mean, it's so glaringly obvious that they're in there. But what the plaintiffs do is they say, look, this advertiser's in California. I've got 10 clients who each receive 15 emails each. I might be able to find a technical violation that'll get me around a motion to dismiss, which is very easy to do in California. And then I'm going to go to the advertiser and I'm going to say, look, here, I'm going to sue you over this, over these emails. And the number, just the sheer volume of the emails make it such that the advertiser at that point has a hard time deciding, well, do I settle this for pennies on the dollar to avoid the litigation expense, or do I buy it? And the plaintiff's lawyers know that. They'll never admit it, but they know that. And so those cases are unfortunate, but they are happening. So the best defense to have there is enable me or whoever is defending it to go to them and say, look, you've got nothing here, and move on. So it's a volume game, and it's a clarity game. But in terms of how do they actually choose their clients, I mean, their emails, it's, who knows, really. I mean, but certainly the first category I went through where there was, 3 misleading features on it, that's definitely something they would go at.
And it's a strict liability statute, right, Ari? So, a lot of the people on this...
I mean, that's what the plaintiff's lawyers say, but I'll never admit that.
Okay. Fair enough. So let's move on to the next topic, which is social media marketing and customer reviews. We got a lot of questions on these, and they are related. They're both governed by the FTC, as well as state laws that prohibit unfair and deceptive acts and practices. So as a result, as a general overview, they're subject to rules regarding truthful advertising, non-deceptive marketing. And one of the big things that we're seeing right now out of the FTC, and it's been a trend for a couple of years now, is, with respect to disclosing the connection, disclosing material connections between an advertiser or company whose products and services are promoted and the person who's going out and talking about, those products and services, whether in social media or, in a testimonial or elsewhere. So the overarching principle that we're looking at when we're talking about disclosing those connections are set forth in the FTC's guides concerning the use of endorsements and testimonials. We really call them the FTC's endorsement testimonial guides. And those require that companies must disclose any material connection between the advertiser and the person talking about the products or services. The material connection can be a lot of different things. The one we always think about is payment to or free products provided to really well-known social influencers. But they can also be things like sweepstakes entry, loyalty points, things that are of value that might not necessarily just be consideration via a monetary payment or product. The other thing is if you have a business or familial relationship to the seller, if you have an employee relationship to the seller that you're going out, whose products you're going out and talking about, that wouldn't be expected by the audience. That is when a disclosure is required. In terms of the format of the disclosure, and we'll talk about this a little bit later because we had a couple questions come in about this, but the disclosure has to be made in the same format as the triggering claim. In other words, if somebody is talking about a product, on Instagram or Facebook, and they're talking about it in writing, the disclosure needs to appear in writing. Nowadays, you have Instagram stories, you got Snapchat. There's a ton of new media coming out. So when for example, when the promotion is occurring, let's say on somebody's Instagram story, they've got a video, then it needs to, the disclosure of that connection needs to appear in video format. The FTC has provided a lot of guidelines over the past couple of years, and they've updated them over the past couple of years to account for different types of media, to account for new platforms. And we've got the hyperlink here to the current guidance for influencers. One thing that's important to point out is that if you're an endorser or if you've got, a review site, it's not going to be enough to say in a hyperlink, such as legal disclaimer or disclosure, that says, consumers have to click on that before they learn that the endorser or the influencer is being paid or otherwise being compensated to promote the company's products. And I'll take a step back here to say that both the influencers can be liable. So the individual influencer who's going out and talking about the product or service, promoting the brand, they can be liable under applicable law. But the company or the brand who's being promoted can also be liable. And it gets really hairy when you have a very large, network of influencers. The larger the number of influencers or affiliates, or if you're using an agency who uses a network of influencers, the more influencers you have, the more people who are going out and talking about your products or disseminating your brand, the harder it is to control those. And so when we're talking about disclosures and we're talking about the requirements, then, when we're talking about those, under the law, you need to know what your influencers are doing. And just because it's hard or you have a large network doesn't mean, you can throw up your hands and say, well, I have too many influencers, I can't keep track of all of them. And so it's important to keep in mind, that you have to have a system in place for your company that is, that you need to have a system in place for your company that is equipped to handle the number of influencers, the network of influencers you may have. The FTC has said in the past in non-binding guidance that they don't expect a company to know what all of its influencers are doing all the time, but it does expect you to have reasonable practices and procedures to ensure that you don't have a bunch of rogue influencers going out making unsubstantiated claims, misleading claims about the product or the service, and who aren't disclosing the connection with you. That's what you can't do. It's really that area in between where you've got, some influencers who are doing it right, and you've got some influencers who are doing it wrong, and you're a company trying to manage that program who's simultaneously trying to get the buzz and the word out about your products and services, but you have to keep an eye on all of this. And so the question really becomes, what do you do as a company? The general idea that the FTC says, sometimes we call it the three-legged stool. The company needs to have influencer, an influencer policy and procedures. Generally, that is memorialized in a contract. It needs to monitor compliance with those policies and procedures and enforce as necessary. So unpacking that, there's a lot of sort of form contracts that we see for influencers that don't really account for the law, the rules or regulations with respect to influencers, and they don't really account for the fact that those laws change. And so a lot of times we'll see addenda to contracts that have specific disclosure requirements, but if you're a company, if you've got long-term contracts, particularly if you're looking, if you're an agency or if you're working with an agency, you need to make sure that your contracts have the flexibility to account for the changes in the law, changes in the platforms and technology, or that you have the ability to change those policies as needed. Monitoring compliance, getting back to that point and understanding that the level of monitoring that you as a company can feasibly do will really depend on how large your network is. I mean, we have companies who nearly all of their advertising and marketing is through influencers. The FTC will take the position, whether or not they're right, that those companies have an obligation to be aware of what those influencers are saying. You have one influencer, the FTC would say, well, you have, it's easier for you to keep track. If you've got a network, maybe reviewing and monitoring a sample of those influencers on a periodic basis. And what we would also say is making sure that you have documented those procedures. So if RA or I had to come in and defend an FTC action or a state AG action or class action with respect to influencer marketing, having those documents demonstrating that you've monitored compliance, and that you've taken remedial action as necessary, that will go very far in a defense. And in that vein, so enforcing is necessary. What does that mean? What are the remedial actions that you have to take as a company? You don't necessarily have to terminate an influencer the second they do something wrong. But what you do need to do is give them a warning. And if you see, ongoing bad activities by the same influencer or by the same agency that's not, taking action against their influencers, then you need to you need to terminate, and you need to have a contractual provision that lets you do that. Here are some guidance on how to disclose. Generally, you have to disclose in a way that's hard to miss. So it should not be buried in a string of hashtags or at the in the middle of a disclosure, or if people have to click more in order to see the disclosure. If you've got an image-only post, you should have the disclosure superimposed on the image. And social media platforms are really making that much easier. So image-based platforms are really letting their influencers do that, and the FTC is well aware of that ability, and so they will hold advertisers to the standard of doing that.
Shane, we got a question that came in about disclosures while we were here. Does the disclosure requirement apply to a paid spokesperson for a charity? And this might dovetail into the FTC's views about endorsement guidelines and that sort of thing.
Sure. And so the disclosure requirements, I'm not sure if the question is whether or not the disclosure requirement applies for paid spokespersons generally. And the answer to that is yes, it does apply for paid spokespersons. With respect to a charity, I'm not sure if we're talking about like a nonprofit organization. That would depend. So, for example, the FTC Act generally does not provide jurisdiction over certain nonprofit entities, but that's not to say that the FTC doesn't seek to enforce its rules and its guidelines against certain entities that it takes a position are violating the law. State laws also, would provide for reach in certain scenarios to charities. So my advice would be that if consumers don't understand that it's a paid spokesperson for a charity, to disclose. If you've got, an ad where you have a very well-known, for example, singer who's talking about donating to an animal rights organization, and it's very easy to tell from the face of the ad that that person is being paid and that they are a spokesperson, then it's likely that the audience would understand that connection, that person is paid, that there is a material connection, and therefore, a disclosure, it's less likely that a disclosure would need to be required. It would be required there. The next area we have is customer reviews. So the FTC is cracking down on customer reviews as well. And I'll separate testimonials and reviews out. And I think testimonials go along the lines of endorsements, where you've got people who you are compensating to talk about a product, and you're compensating them to go out and spread the word. Or a testimonial might be something where you pick a statement that somebody has said and you put that on your advertising. Again, with those, you have to make sure that those are substantiated, they're not misleading, not deceptive. But the FTC is also taking action against customer reviews as well. And if you've got testimonials or you've compensated people or provided them free product to review or provide a testimonial about the product, you have to disclose it. And here's the FTC's position on it. I will not read that long paragraph about it. And I'll pause because we just got a question about how to disclose. And the question is, does a disclosure in a video with verbal content need to be verbal, or can it be clearly written on the screen? So the idea of if, does it need to be a spoken disclosure, or is it sufficient to have a written disclosure on the screen? I hate to say that it depends, but what I will say is that the FTC takes the position that the disclosure needs to mirror the manner in which the claim is made. So if you're making a claim spoken on video, you need to say, I'm a brand ambassador for XYZ company. They asked me to try their product and talk about it. Here's what I have to say about it. So that would be the FTC's position, that if you are if the claim is being made spoken, if it's a video, you need a spoken disclosure. I don't know, and Ari, feel free to chime in here if you want to. Just because that's the FTC's position doesn't mean that a written disclosure would not be effective to consumers. So when we are actually defending these cases, there's a difference between what the FTC expects and what we would argue if we had to go before a court and advocate for our disclosure that might not be spoken. And the position that I would take is that in many circumstances, a written on-screen disclosure that is prominent, clear, and conspicuous makes abundantly clear to the audience that this person is is a paid spokesperson or is being compensated suffices. The problem that the FTC will say is that if there's a video playing in the other room and somebody hears the words, they might not necessarily see the disclosure. And so that's why the disclosure needs to mirror the content. So back to customer reviews. I apologize for the tangent there. The other thing with customer reviews is so in addition to needing to disclose a material connection between the advertiser, the company, and the review, one thing we've gotten a lot of questions about is if you have a product page and you are allowing people to write reviews of those products, are you allowed to filter the reviews as they're presented? Are you allowed to delete some reviews? Are you allowed to present them in a certain way? The FTC's position on that is that it can be misleading, it can be deceptive for companies to either remove negative reviews, so that, let's say you've got a lot of reviews, some are 5-star, 4-star, 3-star, 2-star, ones that take out some of those 1 stars and you only present the higher rated stars. The FTC will say that that's deceptive. They've alleged that in cases. The other thing that we've seen alleged, but not as litigated, is when you filter the presentation of the star reviews. So you present the highest rated reviews first, as opposed to doing them on a date basis, in times that they come in. So the Consumer Review Fairness Act has a couple. It's a law that not a lot of companies know about, but it is something that the FTC keeps in mind. It has a couple of provisions. One of the biggest ones that the FTC is really looking at is the provision that says that you as a company cannot impose a penalty, a fee against somebody who gives a negative review. And so there have been some FTC activity against companies who they'll actually put gag clauses in their contract. Or there's one case that says, there was one case where the company said, we can sue you for $5,000 or $25,000 if you put a negative review. And they actually did that. They threatened, they threatened lawsuits against people who gave negative reviews. The FTC said you can't do that under this act. The other thing that you can't do under the Consumer Review Fairness Act is require consumers to give up all of their IP rights in feedback content, feedback or review, other than a non-exclusive license to use the content. And the reason I raise that is because I cannot tell you how many online terms and conditions I've seen where it's clear that they've been, they're form terms that somebody found off another website where, that probably predated this law, where it said, by providing a review, you grant to us worldwide irrevocable license to use and reproduce. So you can't do that under the law. And although we haven't seen a substantial amount of enforcement around that, something to be mindful of. So that's just something to keep in mind. Here's a case. This was the case that I was talking about, where the company actually filed lawsuits against people who posted negative reviews, trying to take advantage of a contractual provision that said if you post a negative reviews, we'll take action against you. So we have a question saying, if we're sharing customer reviews and testimonials online, do we need to include the customer's name with the review? I don't think so. I don't see an issue with omitting that. I think that any enforcement agency or plaintiff would have a hard time arguing that a customer's name is material to people who are viewing the review.
Well, not only that, in some cases, you might be prohibited from disclosing the person's name. So when it comes to actual consumer names, not only do you not necessarily have to disclose it, you actually might be prohibited from disclosing it depending on what it's attached to.
And so we had a couple of questions about customer reviews. Can we use aggregate star reviews when some of the reviewers were compensated? So this goes back to that idea that you have reviewers who might have gotten free product or for the, to review the product, and then they've given it 5-star reviews, and aggregating those stars with other reviews that weren't compensated. The FTC has actually just issued earlier this year a call for comments about its endorsement and testimonial guides. And this is something that it's specifically looking at. They called for comments about whether or not using aggregated star reviews is inherently misleading, whether, if there's some sort of disclosure or disclaimer at the beginning that explains that some of the reviews were compensated, whether that would suffice to make clear that connection and cure any type of misleading impression. So, that's a long way of saying that, you might be able to do it, but this is something that the FTC is looking at. So if you are going to do that, I would strongly advise using a disclosure, a clear and conspicuous disclosure. Dovetailing into that, what is the current status of the FTC's call for comments on endorsements and testimonials? So the FTC's call for comments, it closed earlier this year. It's reviewing those comments to determine what, if any, changes are needed to the rules. One thing that is important to note is that Commissioner Chopra, the FTC commissioner, who is one of the most aggressive, has stated his intent that he would like to codify the FTC endorsement guides into formal rules so that they can be enforced pursuant to the FTC's Section 19 and 5M powers. And that's something that goes to the ongoing litigation where the FTC's ability to bring lawsuits in court under Section 13B is being challenged and is going to be reviewed by the Supreme Court. And so all that's a long way of saying that the FTC is looking to sort of put more bite behind the endorsement guides. Is the FTC targeting influencers? Over the past couple of years, the FTC has sent informal informational letters to individual influencers saying, look, when you talk about products and services that are compensated, you need to disclose that. But Commissioner Chopra also made clear that he doesn't think that the appropriate enforcement mechanism will be to enforce after individual influencers, but rather it makes more sense to target advertisers and large companies who are the ones who are paying the influencers. And that's generally what we've seen. I mean, if there are influencers who are also, let's say, principals in the company, there was a CSG Lotto case from a couple of years ago, where that is the case, then yeah, we do see the FTC target the influencers, but not really individual one-off influencers like we see.
So we got a question that we were gonna cover, I think, anyway. But before we get here, we have an audience question: is disclosure in hyperlink with a checkbox that says, by checking this box, you agree to terms and conditions, and the consumer would not have to click link and see information in the hyperlink? Great question. Here's the answer on that disclosure. If the information is material to a consumer's decision to purchase, like a pricing term, or it's specifically governed by a statute that has to be specifically disclosed before payment card information is collected or before personal information is collected, it cannot be disclosed for the first time in a hyperlink. Period, full stop, end of discussion. What you can use the hyperlink for is to explain or elaborate the terms. Can't use the hyperlink to change them, but you can use the hyperlink to contain details about an offer that are less than material. But what you can't do is present an ad or funnel through for a consumer to review and give them some of the material information. I'm hoping it's never none of it, but some of it in the funnel and some of it in the hyperlink. That's going to get you sideways. Not only with the FTC, but with the attorney generals and class action lawyers They love that stuff. It's sort of low-hanging fruit. We had another question come in about sharing customer reviews. It looks like if we're sharing customer reviews and testimonials online, do we need to include, oh no, I'm sorry, we answered that one. It was a different one, sorry. Can you edit customer reviews? As long as you aren't changing the spirit of the review. Good question. You definitely can't do it. I mean, I don't know about spirit. You can obviously format it in a way to display it, but if you're quoting a consumer, the safest thing to do is not to change it, because if anybody's ever challenging that quote and they ask for the original, I mean, it depends on the quote, right? I mean, you might get into a situation where you're saying, okay, well, if you hadn't shortened it or you hadn't added these words, or you made the consumer look like he or she said something that he or she did not say, that could get you into trouble. But if they write you like a 10-page letter and you want to quote part of it, obviously you don't have to use 10 pages of your website's real estate to get that testimonial in. You just have to make sure that whatever portions you do use are not misleading and would not change the substance of what the testimonial or what the 10-page letter in my example did. Like everything else, it's a case-by-case scenario. The safest thing is to not change anything, but if you have to, be smart about it. And, the spirit of the review, that's one way to look at it, on it. And now I think we're going on to competitor challenges, right, Shaheen?
Yeah, one I'm just going to addendum to what you just said. What you can also do is if you want to change the review or shorten it, is that you can actually make that change, send it, contact the customer and say, hey, we really appreciate your review. We'd like to use it in a marketing email. Here's the way we want to say it. Is that okay with you? And you can really get that agreement through very short, simple language through an email. I mean, I truncated it a bit, but the idea being, give that review back to the customer, say, is this, would you be comfortable with this? Is it okay if we use this? And with that, we'll move on to competitor challenges.
Yes, and we actually had a question come in about 20 minutes ago on this topic, and we saved it for now, but it's a good segue into the discussion. The question that was asked is if we research a competitor's benefits and disclose in our marketing that our competitor does not offer something, and the competitor contacts us and says that they do, and our marketing is wrong, and fix it, and we do, at what point is there liability if we keep fixing our unintentional false representations? I don't know whether that was intentional or not, but that question was very well worded. If we keep fixing our unintentional false representations. Okay, legal answer and practical answer. The legal answer is especially under some state statutes, it's not, knowledge isn't a requirement. I mean, if you commit false advertising, you commit false advertising. If you damage your competitor, you could be liable. That's a very simplistic way of putting it, but that's technically true. If it's a true one-off where you did your research, you're certainly not going to get hit with, sort of those punitive, exemplary, multiple damages type situations, on that. But if it's a true one-off, as a practical matter, you might get a cease and desist and then just end it. Hopefully that it stops there. As a practical matter, that's what we see. The government, it has to be pretty egregious and wide-reaching. We have seen the government go after situations like that, but it has to be massive. So there's some degree of practicality that comes into it. It's sort of like going 1 mile an hour over the speed limit. Technically, it's illegal. You can get pulled over. You can get a ticket. I'm sure somebody has on this planet. But is that likely to happen? It's not likely to happen, but it's possible. But if you keep fixing it, if there's a record where you keep running into the same advertiser for making the same claim, and it's sort of, or you're in the same organization, you have the same types of complaints that are continuing to come in, that, that's going to make it harder if you ever get into discovery to defend that kind of case because you sort of have that history. It's not per se unlawful just because you did it 5 other times means that on the 6th time that you're liable, but it is a red flag that should be identified and corrected. I mean, I couldn't really give a specific answer on that because there's the technical and the practical answer, and like everything else, it depends. But what I liked about that question is, keep fixing our unintentional mistakes. There might be some issues there if you have to keep doing it. But the good news is that you took some research and you had some substantiation, if you're making claims, for example, to make the statements that you did. And that is a defense. That is a defense. So other competitor challenges, what to do.
So we had a question that's sort of on the other side of that. My competitors making false advertising claims. What can we do about it?
Right. So you can do, well, there's one bullet on here that isn't here. Nothing. Sometimes that's the right answer, by the way. Why? Because you don't want to expose yourself. I mean, when I'm on the receiving side of a cease and desist, I ask myself 2 questions at the same time. The first is did my client step in it? And 2, what can I go after these guys for if they won't go away? So once, sometimes the answer is nothing. But if you wanted to do something, you can send demand letters. You can file a lawsuit under the Lanham Act or many state FTC statutes. You can go before the National Advertising Division, Shaheen's favorite. She's our resident expert of all of our 800 attorneys on that point. Walk you through all of that. It's less public, and it could still be a real pain in the side for advertisers that are being challenged. And then, of course, I think we just said the demand letter. So you have a lot of different ways to handle it, and how you do it will depend on your particular circumstance. Of course, there's cost is also a factor. I mean, obviously, the cheapest thing to do is do nothing, and the most expensive thing, maybe government petition and outreach can be really expensive if you really have to lobby. But as a practical matter, the most expensive piece is going to be a lawsuit, and that should be for obvious reasons. So do you want to talk about, well, I mean, there's the Lanham Act. I mean, that's the federal trademark infringement, dilution, false advertising. That is, a very powerful, commonly used statute in a situation where you're challenging a competitor. You often see the state law claims almost, I can't think of a state that doesn't have a mini FTC law or a mini, that incorporates this idea of the Lanham Act, where you can go pursue a competitor for unfair competition under state law. The remedies are different, and what you have to show might be different from state to state. But in the large, that is a place you can go. And that is worth looking, and those claims are often brought side by side in addition to whatever common law claims that might exist. But those are the 2 go-tos. National Advertising Division, this is an interesting one, Shaheen.
Sure. So the National Advertising Division is a self-regulatory body of the BBB national programs. It allows competitors to bring claims against advertisers, and sometimes the NAD will bring claims on its own, but right now we're talking about what can you do. You can go before the National Advertising Division and lodge a challenge. The filing fee of a challenge, will depend on your size, but essentially, what you do if you want to go before NAD is you provide the advertising claims that you want to challenge, and the burden is then on the advertiser, the one making the claims, to substantiate the claims before NAD. NAD has a substantial amount of experience looking at advertising claims. I think they've been around for 40, maybe 50 years now, I don't know, but a really long time. NAD will review the substantiation provided by the advertiser. They'll review the arguments. They'll meet with each of the parties, ex parte, so on their own. And then the NAD will issue non-binding recommendations. It'll issue findings as to whether or not the claims are substantiated or whether they should be modified or discontinued. The recommendations, as I just said, they are non-binding, and so they don't have the force of law. You can't, and that's the only remedy before NAD really is these recommendations. There's no monetary remedy like there would be in a Lanham Act or a lawsuit under state law. If the advertiser making the claims does not participate in the NAD process, or if there's an NAD decision that the advertiser refuses to comply with, then the NAD will recommend or refer that case to the applicable agency. So a lot of times in our industry, it'll be the Federal Trade Commission. If it's a product such as a food or dietary supplement or cosmetic, oftentimes it will also refer the case to the Food and Drug Administration. So the NAD has a number of processes nowadays too that advertisers can go through. Over the past, in the past, it's been a very long, drawn-out process. I don't mean to say long, but compared to going into a court and filing a temporary restraining order or preliminary injunction, it might take a couple months before NAD. They've recently launched the SWIFT Fast Track program that provides advertisers, I think from start to finish, it might be 20 days, 20 business days, that you could get a decision. And it also has now a complex track for cases that are a little bit more complicated, that the substantiation is a bit more involved. And so it's offering a number of options now for advertisers. And that's sometimes, that's often a good forum, even though you might not get the same type of relief you could get in a lawsuit. It is a good forum because it does provide, it is something that is watched by others in the industry. It's picked up sometimes by, private litigants. And it's a way to show that you are protecting your brand, you're protecting claims that your competitors are making. So along those lines, Ari, do you want to talk about sending demand letters and what circumstances somebody might want to send a demand letter in?
Yeah, so sending a demand letter, it can work. It's a quick, immediate way of addressing a situation and hopefully getting your competitor to act. And it can work. It's a very commonly used method to do it. It doesn't have the shock and awe that a lawsuit has. But at the same time, when you send a demand letter, you've got complete control over what it says, who it goes to, and when. If you were to make, let's say, a petition to the government or reach out to somebody, once you've done that, you've lost a lot of control, maybe not complete control, but in some cases you have control over the situation where the government actor at that point may do nothing, may do something, may reach an agreement that is inferior to what you were looking for. So if you want to, maintain some semblance of control over it and keep your costs down, that's a reason to do it. Plus, it's not necessarily public. And what I mean by that is unlike a federal lawsuit, which hits the docket right away and it's public and never goes away, the demand letter doesn't have that kind of publicity. But what I always tell my clients is assume that it will. If you send this outlandish, demand letter to somebody, and you should assume that it's going to be posted on the internet. And that can backfire. They can say, look, this big bad company is trying to squash the little guy with all this legal stuff in it, and we're not even doing half of what they say. And I've seen that a lot on that. And you gotta be careful with the demand letter. Same thing with the lawsuit too. You don't want to be overbearing on that. And then where I wouldn't send a demand letter is a situation where I mentioned earlier is if the harm is de minimis compared to, exposing yourself, especially if you're going to a competitor. You're sort of putting yourself out there. And if it comes to me and I get it and my client says, look, we didn't do anything wrong. And then they said, well, wait a minute. We hadn't looked at our competitor in this way before. It looks like they're infringing on our stuff and they're doing things that are unfair in the marketplace. Yeah, it's unrelated to what they're complaining to us about, but shouldn't we be doing something about this? So you got to make sure that you've got a clean house before you send that demand letter. Obviously, that's the same thing for a lawsuit because the first thing I look for is a counterclaim.
Right. And also I think when you're sending a demand letter, you have to be really careful about what you're demanding there at the end. You don't want to be, demanding anything that you might not be entitled to or that could get you in trouble, under other laws. So let's take, I know we only have a couple of minutes, but let's take a couple of the other questions that we had. And again, if we don't get to your question, we'll reach out to you after the webinar. So we got a question about state auto renewal laws. What are the updates and laws governing automatic renewal programs? Can you talk a little bit about the cases that are rising under those updates? So there are updates and laws concerning automatic renewal programs. DC, I think, recently amended its law with respect to free trials. If you have a if you're offering a free trial, you have to provide a notice to consumers. I think it's now between 7 and 15 days, but I'll double check. You have to provide a notice prior to the end of the free trial program. California has just proposed an amendment to its automatic renewal law, which is very, very heavily litigated. That would require companies offering free or discounted trials to provide a notice before the end of the trial and offer the ability to cancel. If that notice is provided electronically, then you have to provide a link in that notice that would allow people to cancel. Vermont amended its law, I think, earlier this year, and that amendment now requires companies to offer a cancellation mechanism that mirrors the sign-up mechanism. In other words, if you let people enroll in a program online, you have to also allow them to cancel online. Have there been any recent enforcements under ROSCA or state law equivalent? Yes. The FTC announced an action against MyLife, an online reputation company, for its automatic renewal practices. We also saw a couple months ago that the California District Attorney's, their task force, their automatic renewal task force, brought a lawsuit against, had a settlement with Care.com for its auto renewal practices. Ancestry.com just had a lawsuit. I think Bumble just had a $25 million class settlement. I'll also say that we did, as litigators, we did have one win out of California in a lawsuit involving Google, where the court said that if you as a private plaintiff are going to allege violations of California law arising out of the arising out of the automatic renewal law, you have to show a connection between the violation and monetary harm the plaintiff suffered. So it's provided us with, a defense in those lawsuits, another tool in defense attorney's arsenal. What are the FTC, state regulators, private plaintiffs targeting? The big things they're targeting is the failure to disclose the material terms of the offer. In other words, people who are signing up and getting enrolled in these programs do not know what they're signing up for, don't know what they're going to be charged. Another really big issue is a cancellation mechanism. You're making it.
This gets back to the question we got earlier. That's why this is a hot area, even if it's in a hyperlink. If the subscription terms, the automatic renewal terms, they're not there, but if the consumer has to click on a link to see them before checking out, that is low-hanging fruit.
That's right. That's right. I think we have time maybe for one more question, Ari.
Sure.
This is a long one. So if there's a product that has an uncertain regulatory framework, or where it's really dangerous to make certain claims about the product or the ingredient, but the ingredient, there's a lot of information on the market about the ingredient, about the benefits, and that information on the market may or may not be true. So the example might be CBD was one example. Is that external information and knowledge of that information, is that the basis for an enforcement action that the offer is deceptive because the market is self-deluded? I really like that quote. Ari, do you want to take that one?
Yeah, I mean, I don't really want to take it, but I will take it. Tough question. If it's a regulated product or an illegal product, then obviously that could raise some issues by itself, just by selling it if you're making no claims. And it would have to be a situation where the government, and this would really be a government issue, I think, and the class action lawyers would probably follow along, but I think the government would have to initiate it, where they've just decided to wholesale ban or target a specific product line. It could be something like, I'm not saying it is CBD, but I'm saying it could be something like CBD. And in which case, if you know that's sort of, a lightning rod for these kinds of claims, then yes, just selling it could be. But if you're not making any express claims about it and there aren't any, it's just, I think it's a lot harder to make out that claim just because other people are doing it, then you would be liable too if you're not making the claims. I mean, the way I look at it, and this was sort of unique, if I were a regulator, I would say, well, where are you putting that product on the shelf? If you've got your product in the middle, it's not making any claims, and then you've got, product to the right, circle all around it, and they're all making the claims, and there might be something there given the way that you sold it. I've never seen that claim being made in this kind of false advertising case. But I mean, I could see that argument in this context, but that would be, a very interesting, I think, relatively new way to present it. So stay tuned for that.
Yeah, and I think we're out of time, so I apologize for that we couldn't get to all the questions. We will reach out to the questions that we had during the presentation and those we couldn't get to that you sent before the presentation. But if you have any other questions, any follow-ups, if there's something you think somebody should have asked but didn't ask, please feel free to contact us. Our contact information is here. I believe everybody will be getting the slides as well. So thank you again for joining us. We really appreciate the questions, and we hope this was helpful to everybody.